The number of laws criminalizing homelessness has increased significantly in recent years. A 2019 report by the National Law Center found that there were over 1,500 anti-camping ordinances in place across the country. Critics argue that these laws criminalize the state of being homeless, pushing individuals into the criminal justice system instead of providing them with needed resources and support. 1. California. Describing the anti-homeless law in California is a bit tricky, because there isn't one single law encompassing the entire issue. Instead, there's a patchwork of legislation and local ordinances targeting various aspects of homelessness, some enacted at the state level and others by individual cities. In 2023, California passed a controversial law prohibiting sitting, lying, or sleeping within 1,000 feet of certain sensitive areas, like schools, daycare centers, parks, and libraries. This law faces legal challenges and ongoing debate. Critics argue it criminalizes basic human needs and pushes homeless people out of sight rather than addressing the root causes of homelessness. Los Angeles Municipal Code 56.11 prohibits storing personal property in public spaces, a measure criticized for disproportionately impacting homeless individuals. Many cities across California have enacted ordinances banning camping in public spaces, often with varying buffer zones around critical infrastructure like bridges, government buildings, and schools. These bans, while sometimes coupled with shelter resources, can criminalize basic behaviors associated with homelessness. 2. Missouri. Missouri's anti-homeless legislation, Senate Bill 1106, passed in June 2022, ignited a complex and contentious debate. This law criminalized sleeping on state-owned land, incentivized local governments to enforce anti-camping ordinances, and redirected funds from permanent housing to temporary shelters. The law makes unauthorized sleeping, camping, or long-term shelters on state property a Class C misdemeanor, punishable by a fine of up to $250 and up to 15 days in jail. Supreme Court decision October 2023, the Missouri Supreme Court struck down SB 1106, deeming it unconstitutionally vague and infringing on fundamental rights. This decision temporarily ended the law's enforcement. With the Supreme Court's ruling, the core provisions of the law are no longer enforceable. However, the debate surrounding homelessness and its solutions remains ongoing in Missouri and beyond. 3. Florida. The landscape of anti-homeless laws in Florida is complex and multifaceted, with both state-level legislation and local ordinances contributing to the issue. Florida has a statewide ban on camping in public places, with exceptions for designated campgrounds and parks. This effectively criminalizes sleeping in public, a basic necessity for many homeless individuals. Several cities in Florida have banned encampments, which are temporary dwellings set up by homeless individuals. These bans often lead to the confiscation of belongings and can make it difficult for people to find safe places to sleep. Critics argue that these laws criminalize poverty and homelessness rather than addressing the underlying causes of these issues. They also raise concerns about the violation of civil liberties and the potential for discrimination against homeless individuals. 4. Texas. It's important to clarify that homelessness itself is not banned in Texas. However, there are some laws and policies in place that restrict certain activities associated with homelessness, particularly camping and sleeping in public spaces. In 2021, Texas passed a law prohibiting camping in public areas without prior authorization. This applies to everyone, but it has a significant impact on people experiencing homelessness who may rely on public spaces for shelter. Violators of the ban can face fines of up to $500. 5. Tennessee. In 2022, Tennessee passed a law making it a felony to camp on public property, including parks and under bridges. This law has been criticized by advocates for criminalizing homelessness and pushing people further into the margins. Violations can result in up to 6 years in prison in a felony conviction, potentially causing further hardship and barriers to reintegration for affected individuals. Advocates argue the law punishes people for their circumstances rather than offering support and resources. Critics claim it criminalizes basic necessities like sleeping and adds to the stigma surrounding homelessness. In March 2023, a new bill was proposed in Tennessee to allow local governments to establish secure homeless encampments and facilitate court-ordered mental health treatment. This alternative approach reflects shifting perspectives on addressing homelessness. 6. Idaho. In 2018, a federal appeals court ruled these ordinances unconstitutional based on the Eighth Amendment's prohibition against cruel and unusual punishment. This ruling, known as Martin v. Boise, stated that criminalizing sleeping outdoors, when no shelter beds are available, is akin to punishing someone for their status as homeless. Boise appealed the ruling to the Supreme Court, but the court declined to hear the case in 2019, effectively upholding the Ninth Circuit Court's decision. The Martin v. Boise ruling set a precedent in the Ninth Circuit, which covers western states including Idaho. This means cities within the circuit cannot enforce similar ordinances, unless they can ensure shelter availability for their entire homeless population. As of January 6, 2024, there is no active anti-homeless law in Idaho. There were, however, past legal battles surrounding ordinances in Boise that criminalized sleeping and camping in public when no shelter beds were available. 7. Oregon. The legal landscape around homelessness in Oregon is complex and evolving, with a mix of state legislation and local ordinances navigating the delicate balance between addressing public concerns and protecting the rights of individuals experiencing homelessness. Cities in Oregon, like Portland, have implemented camping restrictions on public property. These restrictions generally prohibit camping in certain areas, during certain times, such as near schools or during business hours. However, these ordinances cannot be enforced if there are not enough shelter beds available to accommodate the entire homeless population. This is due to a 2019 federal court ruling that criminalizing sleeping outdoors is unconstitutional if there are no alternative options. HB 3115, passed in 2021. This law prohibits cities and counties from criminalizing sleeping or resting in public spaces due to a 2018 federal court ruling. However, it allows local governments to pass objectively reasonable camping codes, with restrictions on time, place, and manner of outdoor living.